What you see here is the Constitutional Court of Belgium. And on Thursday, 17 July, the court referred a question about Pillar 2 and more specifically the undertax payment rule or UTPR rule to the Court of Justice of the EU. Now, a lot of people are excited about this because they think it might be the end of Pillar 2. That is an expectation which is completely unjustified and way over the top. Even if Belgium were to lose this case, what it will mean is that Belgium and maybe the rest of Europe, because they do it based on the EU directive, will need to change the way that the UTPR within Pillar 2 is implemented. So let's look at what all the excitement is about. Now, there is a lot of hypocrisy and technical misunderstandings around Pillar 2 and about what's going on in the Belgium case. So a quick 1-minute summary. If we look at the figure on the left, we have CFC controlled foreign company rules, or as they call them in the US, Subpart F rules. Now let's say US Co, which is subject to 21% tax, holds an intermediate parent entity in country A, which is subject to 20% tax, which holds a subsidiary in country B, BCO, which is subject to 5% tax, and USCO also holds a subsidiary CCO in C, which is also subject to 5% tax. Now, the way that CFC rules work, let's assume that both country A and the US have CFC rules. First of all, country A will, under normal CFC rules, say, okay, you've got a low tax subsidiary, and under various scenarios, whether the income is passive or not passive, whether it's dividended out or not, a lot of things can influence this. It will say, okay, you only paid 5% tax in country B, so you need to pay another 15% tax in country A because you are undertaxed in country B. And then the US might go one step further and say, no, our subsidiaries should not be taxed at 20% only or 5% only. They should be taxed at 21%. And the US might levy another 1% or might levy another 21% and then give a credit for the 20% tax that was paid already. And then as far as country C is concerned, if the US Subpart F rules function properly, then the US will levy another 16% tax on the profits of CCO in C, even before those profits are distributed. In other words, what the US does is it treats CCO as if it is a PE, tax that income currently, and it gives a credit for the taxes that was paid in country C. Now, if we look at Pillar 1 and we look at the income inclusion rules, then you will see they work just like the CFC rules because they are CFC rules on steroids, right? First of all, you would have the IIR under the US, which means that the US has as ultimate parent entity the first right of taxation of the low tax income of BCO in B. It is not the IPEA that can tax that, it's the US. But since the US does not adopt Pillar 2, then the Pillar 2 rules say, well, then we will have BCO will be taxed in country A, and country A will levy the IIR top-up tax, right? This is oversimplifying the facts because obviously the US does, even if it doesn't have IIR, it does still have CFC rules. So the US would have taxed the income in BCO under its own CFC rules or its GILTI rules. And then in IPEA, in country A, there never would have been an income inclusion tax because the tax paid by the US under the Pillar 2 rules would be cast down to the taxes on BCO's income, and IPE would say, you know what, you've already paid at least 15% tax on the profits, and therefore we do not need to levy any top-up tax. And then as far as the taxes in country C is concerned, there the US still doesn't levy an IIR because it doesn't implement Pillar 2, but it has CFC rules and guilty rules. And if they function properly, the US will still levy the top-up tax. And there will be no other taxes left because CECO's profits between the US and C would be subject to at least 15% tax. And now we come to the controversial part of the Pillar 2 rules, the UTPR, which this case is essentially about. And what happens here is we have that there is an IIR levy on the low tax income of BCO in B in country A, the IPE, but that's only if the US CFC or subpart F and guilty rules do not work, because when they work, that taxes will be cast down to BCO and B, and when the IPE in country A sees whether it needs to levy any top-up tax to 15% on BCO's income, it will say no, because that income was already taxed in the US under the US CFC or guilty rules. There is no top-up tax due. But if now the US CFC or guilty rules are dysfunctional and do not work, then IPE in A can tax both the income of BCO under the IIR rules, because it is a shareholder and the ultimate parent entity have not levied the tax, and it can tax its sister company under the UTPR rules. And this is the unique part of Pillar 2, is it has a backup for when CFC fail, right? So now IPE in country A is going to tax the low tax profits of CECO in country C, and it can go even further, because they can also say, you know what, US, if you, for whatever reason, pay less than 15% tax, and I'm not talking about the new G7 deal between the US and the rest of the G7, where they will not levy a UTPR and all those things. I'm talking about the way the global rules work, because these are the rules which are being subject to litigation in Belgium. IPE in country A would even be able to levy a UTPR on USCO if USCO is under tax. So this is the background. I want you to be aware of the fact that Pillar 2 largely functions exactly like normal subpart F rules and CFC rules and the guilty rules. And as a matter of fact, let's not forget that the US literally invented CFC rules. They were one of the first, if not the first, to implement CFC rules in the world. The only new thing about Pillar 2 and the UTPR rules is that you do not need ownership in a company to have to be liable to pay its top-up tax. That is the new part, and that is the litigated part. So let's see if the fact that you are not a shareholder directly or indirectly when you have to pay the top-up tax matters. So if we look at Article 7, it is quite clear. It says profits of an enterprise of a contracting state shall be taxable only in that state unless the enterprise carries on a business in the other contracting state through a permanent establishment. In other words, if you have no PE, the profits of a company cannot be taxed in the other country. Now, this doesn't quite match with withholding taxes on interest and withholding taxes on royalties and maybe even services, but let's leave that aside. In the past, there have been taxpayers that argued CFC rules are not in line with Article 7 because you're taxing the profits of a company without that company having a PE in your state, the parent state, right? And then the OECD during the BEPS action plan discussed this And they came up with the following explanation as to why this is not true. They said, as confirmed by paragraph 3 of Article 1. So they discuss this issue in Article 1 and in the commentaries and in Article 7 and in Article 10. They go on to say, the paragraph, I'm looking at the yellow text here, does not limit the right of a contracting state to tax its own residents under controlled foreign company provisions, even though such tax imposed on these residents may be computed by reference to the part of the profits of an enterprise that is a resident of another state. Tax so levied by a state on its own residents does not reduce the profits of the enterprise of the other state and may not therefore be said to have been levied on such profits. So if we take the situation that we had before, we have USCO at the top and we had CCO in C, which was only subject to 5% tax. Now, if the USCO needs to pay additional taxes under GILTI or under Subpart F on the low tax profits of company C or sub-CCO, then what this says is, you know what, the US is not taxing CCO. The US is taxing the US company, a resident in the US. It's taxing its own residents, so there's nothing wrong and there's nothing against Article 7. The fact that the tax that is calculated and due by USCO in US is done on the basis of the profits of CCO doesn't mean that when USCO pays those taxes that CCO gets poorer. CCO and country C retains all the taxing rights that they had before Subpart F taxes were levied, right? And now the question is, I mean, if the OECD finds that CFC are defensible and not in breach of the treaty, does this apply for IIR and UTPR rules as well? Now, the first point is in applying the IIR, a country taxes its own residents, just like under CFC. It does not tax the residents of another country. So it seems like the IIR should be okay if CFC rules are okay. And here comes the interesting part. In applying the UTPR, a country taxes its own residents, just like under CFC rules. It does not tax the residents of another country. Just because Belgium, if that was our IPE in our example here, needs to pay taxes on the profits of CCO, it doesn't mean that USCO must now pay taxes in Belgium. It doesn't mean that CCO must pay taxes in Belgium. It means that the Belgian company, IPE, needs to pay taxes in Belgium. IPE is resident in Belgium. It is taxed in Belgium, right? If the OECD arguments work for CFC, it must work for IIR. IIR is a globally harmonized CFC set of rules. That's all it is. Seems like a lot of people are not quite understanding this point. In addition, if the OECD arguments work for CFC and IIR, it must also work for UTPR. The basis of the OECD defense for CFC rules is not the ownership chain. It is the right of a country to tax its own residents. And what you do under the UTPR is the Belgian IPE company pays taxes in Belgium, but the taxes that are due are calculated based on the profits of CCO. Nothing in there requires ownership. That's not the way the OECD argument works. And then finally, the UTPR backup for the IIR under BEPS Action 1 operates similarly to the backup rules for hybrid mismatch arrangements under BEPS Action 2. Now, if you remember BEPS Action 2, part of the strength of the whole BEPS Action plan was for every anti-abuse rules, there were 3 or 4 other backup rules, right? And under BEPS Action 2, the main rule was if you have a hybrid instrument or hybrid entity or something like that, then the country which makes the deductible payment should deny the deduction. But not every country was going to follow the OECD rules. And therefore, the OECD said, well, if the country that should deny the deduction does not deny the deduction, then the country that would have exempted the income, because remember we're talking hybrids, cannot exempt the income anymore, and it must tax that income because it was deductible in the payor country. In other words, there's a backup mechanism. And just like there was under Pillar 2, under BEPS Action 2, there is a backup mechanism under BEPS Action 1, under Pillar 2, and that is if no one levies the CFC IIR top-up tax when they should, then the backup rule is then the other party or another party must go and pay a UTPR. So we make sure that this group cannot hide low tax profits anywhere. That was the whole aim of the game under Pillar 2. We need to make sure that multinationals cannot hide their low tax profits in Bermuda or the British Virgin Islands or wherever it is that US multinationals hide their low tax profits. So now let us get back to the case and look at the decision itself. And I will put the Dutch text at the top, and then I will put the translated text at the bottom, and we will discuss it. So the case was filed by the American Free Enterprise Chamber of Commerce. I think an organization probably incorporated for the event, but I don't know. It is supported by the Arkansas and the Kansas states of chambers, the chambers of commerce. Nothing national, nothing the U.S. Chamber of Commerce or something like that. No, these local tiny little things, and then two other local American business organizations, right? And they argue on the admissibility of the request. To support the request, the requesting party, so this American Free Enterprise Chamber of Commerce, argues that its statutory goal is to defend the collective interests of American companies and government agencies. That interest can be affected by the contested provisions, UTPR. I don't know why they don't contest IIR at the same time, because, like I said, the one precedes the other. Since they oblige the Belgian tax authorities to determine a so-called UTPR addition, while the American legislator has not introduced the so-called Pillar 2 rules. Now, if you think for 5 seconds about this, you realize the total bogusness of this rule, because what they basically say is if the US has not done a rule, then other countries are not allowed to do those rules either, which sounds very arrogant. And then the Belgian ministers have also responded, and they say the Council of Ministers dispute the importance of the requesting party. It has not demonstrated that its objective could be affected. The objective would only be effective if it has members that fall within the scope of Pillar 2 rules. So the Belgian government said, you know what, you've got no companies with subsidiaries in Belgium where the UTPR surcharge is going to apply. And here is the crux. They say, in reality, the requesting party with the present petition strives for a political goal. And let's just take a step back and see how these cases come to be. Because I very much doubt, I've seen this many times before in many other cases. I've spoken to instigators of these cases. Some of them are even friends of mine. So you think that something is wrong with law or something like that, and you want to fight this, but you need a real case to go to court, right? So what you do is you try and find a case. You ask among clients, you ask among friends who have clients, do you have a case like that? In the worst case scenario, if you don't have a company like that, you incorporate a company and you generate the situation, right? Otherwise, what you do is you go and find, I mean, once you found a company, you need to realize companies are terrified of sticking out their necks, right? So the company doesn't want to litigate in its own name. It's afraid of reprisal. So now the company wants to hide behind a business organization, right? So now we put in a business organization to represent all its members, and then you get to these the Arkansas and the Kansas state chambers of commerce, whatever they are. Bear in mind that most Americans do not know where Belgium is, right? But they are very concerned about the Belgian UTPR rules. And then you go and you run these cases. And again, I mean, this was probably instigated by Dutch and Belgian tax advisors finding US customers with great difficulty or not, who then find a shield to hide behind, and now they're going to attack Pillar 2, and they start with the UTPR because they think that is the place that they have the best chance of success. So let's see what happens. Now, bear in mind, at this stage, the Belgian Constitutional Court has the opportunity to simply blow the case out of the water and say, you know what, you are a bunch of American um, interest groups. You've got nothing to do under Belgium and Belgium taxing its own residents. Go away. But that's not what the court does. It takes, I think the easy way out would be um, the better argument because he drops the whole case in the lap of the Court of Justice of the EU instead. And it does so by arguing the following. It says the Constitution, that's the Belgian Constitution, require that every natural or legal person filing an action for annulment demonstrate an interest, and actio popularis is not admissible. So you cannot just do a theoretical case in order to protect the general public good. You must have a real interest in a real case before you ask for annulment of some law, right? And then the court goes on to say, it says, when a non-profit association appears, it is required that its statutory objective be of a specific nature and distinct from the general interest, that it defends a collective interest that is objective could be affected by and that its objective could be affected by the contested regulation, etc., etc. Right? So the same or similar rules seem to apply for non-profit associations, and then the court makes an interesting turn. It says the applicant's statutory purpose is to promote the common interests of its members by defending the collective interests of US companies and government entities with respect to domestic and foreign general policy and legal matters in local, state, national, and foreign jurisdictions. Now, I don't know about you, but if I look at the applicant's statutory purpose, it is huge. Anything that is a corporation, their worldwide interest is to be defended by this entity, right? That is it. I mean, I would say that is very, very far from a specific interest. It covers everything as long as you're not a natural person, but a legal person. But the court says this purpose, distinct from public interest, I very much doubt it, may be directly and adversely affected by the contested provisions insofar as they introduce a UTPR surcharge. These provisions may thus affect the interest of the US companies whose interest the applicant represents. I think this is a humongous, bogus argument. Put it another way, if the Belgian Constitutional Court accepts this as being a specific interest, which allows the participants to go further with their request, then I hope they get inundated by millions and millions of requests because, quite frankly, they've opened the door to more or less ask for anything on anything. And as long as you do not include the total population, it seems that you have something which is a specific interest. And therefore, the court concludes the applicant has legally required interest, and therefore the case can go ahead. Um, and then it does say, as far as there were a number of these intervening institutions, Arkansas and Kansas and all the other institutions, it does say, since the intervening associations, which support the applicant's application for annulment with their interventions, do not add any substantive arguments regarding the applicant's complaints, there is no reason to examine the admissibility of their intervention. Now, I don't know whether this means that these participants are now no longer participants, Or it simply means that they're not saying anything special, but we'll take them along for the free ride with this US chamber, special chamber thing. The court never explains that idea further. I guess we'll have to wait and see what happens in the real decision. So now that it has been determined that the party has standing before the court goes through the complaints, and there are basically four, then they're explained in more details. And the highlights show just that the complaint covers Article 35 and 36 in every of the four instances, right? And 35 and 36 is the implementation of the UTPR in the Belgian Pillar 2 rules. And then in the first instance, they reference Article 10, 11, 16, and 172 of the Constitution, which largely deals with non-discrimination in any form, right? And then also Article 17, 20, and 21 on the Charter of Fundamental Rights of the European Union. Again, it is non-discrimination, it is legal certainty, etc., etc. And Article 1 of the first additional protocol of the European Human Rights Convention. So now you have the Arkansas and the Kansas Chambers of Commerce calling for human rights for non-existing yet US multinationals, which maybe one day might suffer some UTPR on their Belgium subsidiaries, right? And then Article 1, just to be clear, is dealing with the right to peaceful enjoyment of your own property, right? And then you can see the second and the third and the fourth plea again repeats more or less the same articles from the Constitution, and then they also refer to the freedom to conduct business in the second plea, which is based on Article 2.3 of the Code of Economic Law. They again reference Article 15, 16, 20, and 21 of the Charter, which is again non-discrimination, etc., etc. 49 and 56 of the Treaty on the Functioning of the EU, the fundamental freedom, so freedom of establishment and free movement of capital, if I remember correctly. And then on the fundamental principle of legal certainty and the general principle of legal certainty in EU law. And then they continue on in the third plea with more or less the same. And they bring in Article 20 and 21 of the Charter. And this is again these fundamental rights under EU law. And then 10, 11, 170, paragraph 1 and 172 of the Belgian Constitution, again, on the principle, and I think it is 170, paragraph 1, that deals with the principle of fiscal territoriality resulting from the legality in fiscal matters of the Constitution, whether or not read in conjunction with, right? And this whether or not read in conjunction illustrates my issue with these four pleas. I mean, they don't say read in conjunction or not read in conjunction because they don't know. So they throw in both of them, right? And then they also talk about the principle of fiscal territoriality recognized in the case law of the Court of Justice and in customary international law. And I'm not quite sure which cases they refer to in customary international law on fiscal territoriality and whether they are referring to the Vienna Convention on the Law of Treaties. I don't think that that is dealing with tax law and the territoriality principle as such. My issue with these four pleas is it seems like they're taking a shotgun approach. They have no idea which argument might accidentally be successful. So they take a bucket, they throw it at the court, and they say, here, let's see if one of these work, which is just horrible legal practice. And then the court brings in the EU law, right? The court summarizes, it says the four grounds of appeal essentially challenge the obligation for Belgian entities to pay a UTPR without taking into account the financial position of that group entity. Now you need to stop here for a moment and just think, when you have a CFC rule or a subpart F rule or a guilty rule or an IIR rule for that matter, do those rules say, you know what, we are going to look at your own financial situation first before we decide to levy the IIR or the subpart F or the guilty taxes? And to my knowledge, they don't. Yeah, but apparently here that really matters. Yeah, and then it says, and then the court brings in the EU law and its own escape, because now it doesn't have to take a decision for the time being, right? The Belgian Supreme Court or the Constitutional Court says, since the contested provisions implement EU law, remember the directive, the EU has directive implementing Pillar 2, and Belgium adopted the directive, which includes the UTPR rule. The court also examines those fundamental rights in light of the relied upon articles of the Charter. That's the European Charter of Rights, and then there's also Article what was that, 46 or 47 and 56 on free movement of capital and the freedom of establishment, and then also, you know, whether the directive which implements Pillar 2 is in general in line with European primary law, because the directive itself is secondary law and that is subservient to European primary law. And so the court comes to its referral. It says it follows that the application of a UTPR surcharge are imposed by Directive 2022/25/23, which is the Pillar 2 directive. And then it says the court does not have, so the Constitutional Court does not have jurisdiction to rule on the compatibility of the aforementioned directive with Articles 15, 16, 17, 20, and 21 of the Charter, and Article 49 and 56, the fundamental freedoms, with the principle of legal certainty and with the principle of fiscal territoriality. So both the Charter articles, the fundamental freedom articles, the principle of legal certainty, and the principle of fiscal territoriality are all EU law, and the Constitutional Court cannot decide it. It must be the Court of Justice of the EU that must determine it. And the court quotes the law. It says Article 267 of the Treaty of the Function of the EU grants the Court of Justice jurisdiction to give preliminary rulings on both the interpretation of the treaties and of acts of the institutions of the European Union and the validity of those acts. Where there is doubt, the court or tribunal must, even of its own accord, like the Constitutional Court does here, request a preliminary ruling from the Court of Justice. So now we come to the question that the Belgium Constitutional Court has asked the Court of Justice of the EU, and that everyone last Thursday, and that everyone is getting so excited about. So let's see what it says. Now, the question of the court was, do Articles 12 to 14 of Council Directive 22, ensuring a global minimum level of taxation for groups of multinational enterprises and large domestic groups, insofar as those provisions require member states to subject group entities to a UTPR charge without any distinction being made based on the financial capacity of those taxpayer group entities, infringe one, Articles 15, 16, 17, 20, 21 of the Charter of Fundamental Rights of the European Union, or Articles 49 and 56 of the Treaty on the Functioning of the European Union. So we've got the non-discrimination and all that in point 1, and we've got the fundamental freedoms in point 2, or the principle of legal certainty, or the principle of fiscal territoriality. Actually, the court uses the word and, not or, both in the Dutch translation and I believe in the French translation. I haven't looked at the German one. So this is the question that the Belgian Constitutional Court has now asked the Court of Justice of the EU, and it's going to take a couple of months, I think, before we get a response to that. As you might have heard from my cynicism in discussing this case, I'm not very happy with this. I think it is bogus. I think it is nonsense. And I will give you a couple of reasons why. First of all, If the US CFC rules worked properly, we would not have had Irish Dutch sandwiches or BEPS. And what I mean is, if you go back to 2010, 2012, there were a number of scandals where British parliamentarians said to, I believe, Google, we're not saying you're illegal, we're saying you're immoral because you don't pay taxes on your profits outside of the US. The US allowed these Irish Dutch sandwiches to happen. They never closed those down, which meant that the OECD basically had to do the US government's work for it and went through the whole BEPS action plans with all 15 actions to stop overly aggressive tax planning in the world. And let's be honest, the over aggressive taxpayers in the world were the US multinationals. European multinationals had to compete in Europe with US multinationals, where US multinationals had effective tax rates on the European profits of, I don't know, 3 or 4% or something like that. And the European multinationals usually were somewhere between, let's say, conservatively 12 to 20%, a multiple of what the US multinationals were paying on taxes on profits and business in European territory, right? Um, and that's what started BEPS. So the rest of the world was doing the US work for it. The US was happy to participate in making Pillar 2 rules at the OECD for everyone else, because remember, the Pillar 2 project has been going since 2016 until now. And it was only until Trump, when Trump became president, that everything went to hell and gone. The US was already, it was unclear whether they were going to join or not, but they were very happy to join the discussions on making the Pillar 2 rules for everyone else. In fact, it was the Biden administration that determined that the global minimum tax should be 15%. And then Subpart F and GILTI work like Pillar 2 and are extraterritorial taxes. So this thing about extraterritoriality is an argument of convenience, right? And it works just like Pillar 2, except that it applies indirect subs and not sister companies. So that's something that Pillar 2 has different. There is a UTPR. On the other hand, Pillar 2 has a lot of taxpayer-friendly attributes which the US laws do not have. For instance, there are multiple instances in which under Pillar 2 you can tweak the Pillar 2 system so that it matches the local tax rules more than the local accounting rules, which the US rules do not have. And Pillar 2 considers deferred tax positions, the way I understand the US system, do not have. So it's not as though Pillar 2 is much worse than the US system. It is actually better. And I'm not quite sure that our US Chamber of Commerce special interest group is quite aware of that. And then finally, they are so terrified of this UTPR that might be taxed by their interest holders in Arkansas and the Kansas Chamber of Commerce. But the fact is that as long as Subpart F in the US and GILTI in the US functions properly, Belgium would not be in a position to levy UTPR taxes on Belgian subsidiaries of US parents. That is simply a fact, because the UTPR will only kick in if the US and its subsidiaries do not pay at least a 15% tax under local tax rules or ultimately under the US GILTI and Subpart F rules. Only in that situation might it be possible that a Belgian company would have to go and levy some UTPR because the US rules do not work. I think these are very thin and hypocrite grounds on which to go and attack Pillar 2 under a European legal system. You are welcome to disagree with me on this, obviously, but I really find this a waste of taxpayer money. Ultimately, it is you and me that pay for these courts and these judges to waste their time on stopping companies to pay at least 15% tax in every country where they operate. Bye for now.